All right, we're back. Let's go back on the record. We return to our hearing in Township versus Alfred and Joanne Yoder. File number is 25040CZ. Testimony portion of this hearing has been completed. Court's heard testimony under oath. We've received 6 exhibits, and I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate, essentially.
Welcome back, everyone. Today, we're diving into the Township versus Alfred and Joanne Yoder. Case a high-stakes legal battle where defiance meets the court's authority. Heading, the Yoders allegedly continued operating a birthing facility despite a clear permanent injunction and repeated warnings. Over the next few minutes, we'll break down every explosive moment, every shocking courtroom twist, and exactly why ignoring a court order can land you in serious trouble. Who do you think is in the right here, the Township enforcing the law or the Yoders defending their ministry? Stick around because the drama is just beginning, and you won't believe some of the arguments that were made in this courtroom.
In this case, when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. It is very obvious from March 13th through now, and from the exhibit entered on the number of births out there, that the births could have stopped much sooner than they did. And I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders contempt, and I think they are in contempt of Judge Stutzman's and this court's order, was intentional. And only from the township's persistence in getting to this hearing are we here today in almost the end of September. So the township is going to request a fine under MCL 600.1701, actually 600.1715, of $3,500 per defendant, to get the point across that the circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $248
Yes.
or whatever it was. And my understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand we're not going to get, the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township, to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings, the impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, And in today's proceeding, I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. If a policeman charges someone with a crime, with drunk driving, the county pays for the prosecutor, the county pays for the judge. It doesn't work that way for the townships. If the township proceeds to enforce an ordinance, the township pays for it. And if there's a lawsuit, there was a lawsuit in my township that cost the township about $25,000 in attorney fees, and they lost. So my practice is often to just give any court fine money that would go to the court to the township to offset the cost of the case. All right, so you're asking for $3,500 per defendant. The maximum would be $7,500. And that I allocate that as restitution, but we need a bill of costs and a further restitution hearing. All right, thank you.
And the 240.
And the 248. And as I indicated, I've got $2,000 in escrow from their cash bonds that they posted. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat. You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist.
This is where the pressure really starts to build. The township lays out a clean, methodical argument showing the defendants knowingly ignored a court order and kept operating anyway. Every point circles back to intent, not confusion. This isn't a misunderstanding, it's defiance. By the time fines and restitution are discussed, it's clear the court is being asked to make an example and send a message that orders are not optional.
Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to...
Now, this is where the tension skyrockets. The court isn't just talking about technicalities, though Yoders knowingly defied a permanent injunction. They changed the name of the business, but the law sees through that. Intent matters. This isn't a simple misunderstanding, it's clear defiance. And consider this, 87 births over 5 months, completely ignoring court orders, far more than some hospitals see in the same time frame. The stakes are enormous, not just legally, but ethically and financially. The township isn't just asking for fines, they're asking for accountability. So, I've got to ask, would you keep operating in defiance of the law, or would you cut your losses and comply? Let's break down how the court is methodically building its case for consequences.
Somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you. Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. doesn't matter what the name of it is, you can't do this at that place. And you had birth through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. The township has established that you're in contempt for continuing to hold births through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that, and I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order, but my recommendation is find some place where you can do it. Your followers will find you. We're gonna set a second hearing regarding the amount of the fine. And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. Then I'll make a ruling on how much the fine is. We can set that for Wednesday, October 15th at 1:30. Does that work for you?
It does, you know. You said 1:30?
Yes. Mr. Thorne, I'd like you to do an order stating that the court found that the plaintiff had met their burden of proof and the defendants were found in contempt. And the court intends to order a civil fine or restitution. And they will set a hearing on the amount of that fine for Wednesday, October 15th at 1:30. All right, we now have to deal with the other case. Yes, Ms. Yoder?
For the Judge Stutzman hearing, I still feel that was very much, I mean, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry before they made a court hearing. They had all this, and then Judge Stutzman lied about it. He said that we attempted to file our paperwork and we did not. We did, it's all proven fact, it's stamped, it's dated. It was done February 6th.
Well, you can appeal these. His ruling has been made and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. Now, a higher court, higher than me, may have a different view of it. So it's difficult to appeal a case to the Court of Appeals. I've done it, and you'd be very, very difficult for you to do this without legal counsel. And they're probably going to uphold his ruling. So if you want to continue your ministry, my suggestion is you find a place to do it where it conforms with the zoning regulations. Then you can continue with your ministry. Your clientele can still utilize your services, and you'll be in compliance with the law. All right, we have the preliminary injunction. We're going to shift the record here to the next case, which is file 25533CZ. That was the default judgment that entered. Request for default was filed by the clerk. What's the date of this? It's filed August 23rd of 2025. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time is passed. So the date is September 1st. That date is passed, but there should be no further operation of Mama's House at this location after September 1st, 2025. So we're going to take out the reasonable time requirement. The people after that date have found other remedies. All right, let's shift to the new case, Mr. Thornton. That request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness, the township building official, to put on some brief testimony that would add a little bit to the admissions by the Yoders to the complaint, to each allegation in the complaint. And then I would request at that point, once that testimony is received, the entry of the proposed default judgment I submitted in this case.
Mr. Yoder, would you come forward again?
Actually, I don't.
I mean, Mr. Klein, I'm sorry.
Actually, it's Lance Bonifield.
Oh, all right. Mr. Bonifield, would you come forward? Good morning. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And would you state your name?
Lance Bonifield,
Could you spell that for us?
LANCEBONIFIELD.
Mr. Thornton?
And you're employed by whom?
Safe Built.
And again, Safe Built has a contract with Township, correct?
Yes.
To provide building code official services. Is that correct?
Inspections.
Inspections. Okay. And are you the present person that does that in Township for
Yes.
Safe Built and Township?
Yeah, I do plan reviews and building inspection.
And are you familiar with the Alfred and Joanne Yoder's property commonly known as 30246 Marsh Road, Michigan?
Yes.
And this has a fairly recently built, quite large structure on it, correct?
Yes.
Approximately a 6,400 square foot structure.
Yeah.
And as part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
Yes.
Did you do that?
Yes.
It's already established by the pleadings, the verified complaint and the failure to answer those allegations have been admitted that 2 stop work orders entered on this property. Is that your understanding?
Yes.
The first one entered on February 2nd of 2024. Is that correct?
Yes.
And the second one entered on April 8th of 2025. Is that
Yes.
correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
Yes.
But you know that information from reviewing the file.
Yes.
Have, in your review of the file, can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Township?
No, they haven't been.
So they are still in place.
Yes.
Having reviewed Safe Built's file on this matter, can you tell the court whether building inspections have been conducted on the structure located at 30246 Marsh Road?
The only inspection performed there was footing inspection.
Should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done, and I saw that when I went there. We should have had framing, insulation, whatever trade happening there, roofing and final. Those haven't been done.
Haven't been requested by the
No.
Yoders. So therefore the structure has not been inspected.
Yes.
What state is
All right,
this?
let me start. That includes electrical, mechanical, plumbing inspections.
Correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. Or the last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my
Yeah.
understanding?
And it's drywalled and the flooring is in complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms,
Is there a kitchen?
no kitchen. It's not in the drawings.
That's all I have, Your Honor. Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. or Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The affiant, or whatever they want to call it, is signed by Lance Bonifield. And from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
Frank J. Kelly,
Yeah, but what's the name of the parties?
Delaware County v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
All right, county of, what county
And
is that?
on that same,
What county is that?
PA.
Delta County v.
Alright.
City of Gladstone,
Also known as Happy Rock.
on the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney.
He
I
is,
think he's running two different deals on the same. And then if you go back to the search warrant,
And he doesn't have a legal oath of office either.
we've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
all right.
For the, I've got motions here. I'd like to have for you and Lance to have one of these.
Yes, would you hand them to the bailiff? Yes,
If I could respond to what he said.
well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
I'll just wait.
All right, this is, I'll get it date stamped by the clerk. I'll just put filed, bench filed. 9/24/25. I guess it's entitled motion to
Dismiss
Dismiss.
for lack of jurisdiction in violation of constitutional rights.
okay.
Introduction, defendant.
No, you don't need to read it all. I've got it here. again, there's a timing issue. They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special appearance papers.
That's not an answer to the complaint. And then the time to answer has passed. So, all right, yes.
So, as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we brought a response on the date of the hearing with our special appearance forms.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside, and that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time also. The whole jurisdiction issue and this oaths of office, they've cited some of these arguments before. The statute they're relying upon, which is MCL 85.10-16, is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be an oath of office. A building a code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I am aware of that requires a building code official to be to take an oath of office. And I know that Michigan Township Association backs that up.
Mr. Bonnefield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't.
This section shows how fast things fall apart when procedure is ignored. The second case unfolds with testimony that exposes unpermitted construction and ignored inspections, while familiar sovereign citizen arguments surface again. Jurisdiction claims, oath challenges, paperwork theories, none of it moves the needle. The judge explains the brutal reality: once you're in default, you don't get to argue anymore. Belief doesn't override court rules.
Read it. I'll make a ruling on it on October 15th at 1:30. You may proceed with your motion for entry of a default.
Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed, and the additional supplemental testimony given here by Lance Bonifield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
I was looking for the order. As I indicated, these are circuit court pleadings and their on-base system is different than mine. Do you have a copy of that order with you?
I do, Your Honor. I have an extra copy of the default judgment.
I got a copy of the August 29th order.
And the Yoders were provided with that proposed judgment when they were served with the motion. It has not changed from that date.
I order. Skip to the order part. It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The above finding of facts are hereby incorporated and made a part of this judgment. The defendants and their officers, agents, servants, employees, attorneys, assigns, or successors in interest, or anyone involved in participation with the defendants are permanently adjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work or orders have been rescinded by plaintiff's building code officials. This is common. This happens all the time. The case right now when someone built a garage, and I don't know how well built it is, but they didn't get a permit. Or they build a house and don't get a permit. You'd be amazed how often that happens. At any rate, I order that. You're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. Plaintiffs, I'm going to put in here rental room or fees or donation. Plaintiff shall cause a certified copy of this judgment to be recorded in the Officer of Register of Deeds for St. Joseph County within 30 days of the date of the entry of this judgment. No money damages are awarded to Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. The permanent injunctive relief granted in this judgment supersedes the previous injunctive relief granted in the preliminary injunction order dated August 29th. The court retains jurisdiction of the case to enforce the terms of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. I'm going to accept this filing and this filing. I'll ask that the clerk date stamp these and provide a copy of this permanent injunction to the defendants. You have a right to appeal this, but there's a process that is to be followed. This one's a thornier issue. My recommendation is you simply continue your ministry at a different location. A lot of money was spent building this building without a proper permit and without inspections. And we had a case several years ago where a church, they did a large bunch of construction without inspections or permits. They got the girders up to support the church and they didn't match. It was a big mess and eventually it was rectified, but nowhere in the county can you do this, build a building without permits and inspections. So that's my order. I would ask you to go up to the, unless you want me to just mail it to you, I'd prefer to give you a copy today. Could you guys process this and bring a copy back down for the defendants? All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was.
Now,
permitted.
why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, mister, when we got to the point, my wife says, we got to do something different. She's going to need a new building. I says, all right, you go up, you find out what we need. Because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I says, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permits. Okay, so we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they say, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, and now you raise your defense.
We filed personal or special appearance papers on every court case that was filed.
So you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got a not what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did.
Your
So,
Honor.
all right, we're going to be in recess. This matter is completed. You wait here. They'll bring you a copy of the order. You have a right to appeal it. We're going to have a further hearing on October 15th. Where we'll determine what the penalty is, and I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess. Thank you all for being here. This is a public proceeding, and it's a healthy thing that people connect.
This is the
Here's the bottom line. The default judgment is entered. A permanent injunction has been issued, and the intended use of the building is officially shut down. The court made it crystal clear ideology doesn't override legal process. Simply saying I appeal isn't enough. There's a procedure that must be followed. The Yoders case is a textbook example of what happens when legal counsel is ignored and passion takes over. This case also underscores the importance of permits, inspections, and compliance event for seemingly private ministries. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss the next case we dissect.
final hammer. The default judgment is entered, permanent injunction issued, and the building's intended use is officially shut down. The judge patiently explains that saying I appeal isn't an appeal, and that ignoring process caused this outcome. It's a clear lesson in what happens when ideology replaces legal counsel. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next one.